Who is responsible for Taiwan's defense?
Part 39.
History of Florida.
Spanish rule, first period.
Florida was under colonial rule by Spain from 1513 to 1763.
British rule.
In 1763, Spain traded Florida to the Kingdom of Great Britain for Havana, Cuba, which had been captured by the British during the 7 Years' War.
Spanish rule, second period.
The Peace of Paris, 1783, ended the American Revolutionary War and returned all of Florida to Spanish sovereignty. Some 35 years later, in the Adams-Onis Treaty, signed in 1819, Spain agreed to cede Florida to the United States for the sum of $5 million. The United States formally took possession of Florida on July 17, 1821.
In the above historical overview, we clearly see that Florida was ceded to the United States by a treaty which came into force in 1821. Hence, Florida is part of the United States.
Original boundaries of the USA.
As discussed earlier in this series of videos, the original boundaries of the United States were established by the treaty with Great Britain in 1784. The United States then expanded its property through the negotiation of territorial treaties. The above summary of the history of Florida provides one example.
Taiwan.
Contrastingly, Taiwan was ceded to Japan in 1895. After World War II, while it is true that Japan renounced its sovereignty over Taiwan in the San Francisco Peace Treaty, SFPT, of April 28, 1952, nevertheless the treaty did not cede Taiwan to China, either the PRC or the ROC.
In other words, while it is true that after April 1952, Taiwan was no longer under the sovereignty of Japan, but it was not under the sovereignty of China either.
In this regard, it is important to note that the December 1, 1943 Cairo Declaration, the July 26, 1945 Potsdam Proclamation, and the 1945 Japanese surrender documents were not treaties, and could not affect a transfer of territorial sovereignty.
The Vienna Convention.
Many scholars stress the following 3 points.
1. According to Article 2 of the Vienna Convention on the Law of Treaties, a treaty is not affected by its particular designation. 2. In 1978, the International Court of Justice stated that a joint communiqué could serve as an international agreement. 3. Volume 1 of Oppenheim's International Law, 9th edition, states that a document, such as a press communiqué, even if unsigned or merely initialed, can still constitute an international agreement.
However, the fact remains that the leading allies are on record as saying that the Cairo Declaration and Potsdam Proclamation were only statements of intention. At the time of issuance, they were not regarded as binding legal instruments, and certainly not as treaties.
This is important because customary international law in the post-1820 period has clearly established that territorial cession is not simply accomplished by international agreement, but by treaty.
In many countries, treaties must go through a separate ratification procedure.
It is also worthy of note that the most authoritative website in Taiwan regarding local law and legal regulations is law.moj.gov.tw. However, this website does not list the Cairo Declaration, Potsdam Proclamation, or Japanese surrender documents as treaties.
Additionally, we must not forget that the Vienna Convention on the Law of Treaties only came into force in January 1980. To claim that it is authoritative in dealing with the interpretation of these wartime documents is therefore quite problematic.